next case today is State of Ohio versus Matheau Moore. Mr. Moore is with us on video today. He's represented by his attorney, Cord Gatterdam. The state is represented by the prosecuting attorney, Melissa Schiffel. I do apologize for running late today. I had a hearing that went long this morning, and then we had some technical problems here this afternoon on Zoom, so I'm sorry for holding everyone up. We are conducting the hearing today on video, as we are permitted to do by Ohio Criminal Rule 43. That rule does require that I give appropriate notice to all parties before I conduct a hearing on video. I have provided that notice in the case. The rule says, too, I must allow the defendant to hear and to see everything that goes on during a video hearing. Are you able to hear and see okay today, Mr. Moore?
You can, Your Honor.
Good. The rule says, too, I must allow the defendant to speak during a video hearing, and he must be seen and heard by me and by all parties. We are able to see and to hear Mr. Moore today, and I will allow him to speak during the hearing. The rule says, too, I must allow for private communication between the defendant and his attorney during a video hearing. If you did want to have a private discussion with your attorney during today's hearing, Mr. Moore, you could let me know at any time. I could then jump off the call, as could the prosecutor, and you could then speak privately with your attorney. Once that discussion ended, your attorney could let my staff know. I could then rejoin the call, as could the prosecutor, and we could press on with the hearing today. Any questions about that, Mr. Moore?
Understood, Your Honor.
Finally, the rule requires that I secure the consent of the defendant before I conduct a hearing on video. Are you willing, Mr. Moore, to waive, that is, give up, your right to be physically present here in the courtroom with me for the hearing today?
Yes, Your Honor.
We are together today for Mr. Moore's initial appearance on an indictment that was filed here yesterday. In the indictment, Mr. Moore, I see 2 murder charges. If you're convicted on those, you face life in prison, as well as fines on each of those charges of up to $15,000. You're charged, too, with felonious assault. If you're convicted on that kind of charge, you face up to 12 years in a state prison and a fine of up to $15,000. Would you like me to read the indictment aloud or elaborate on those penalties today, Mr. Gatterdam?
Your Honor, waive reading.
And did you want me to go through any constitutional rights today?
No, Your Honor, I've already covered that with Mr. Moore.
All right. It's not guilty pleas today?
Not guilty on each and every charge, Your Honor.
All right. Tell me for some information about your client.
Yes, Your Honor. This is Matheau Moore. Date of birth, January 30th, 1971, making him 50 years of age. Last 4 of his SOCH are 8947. Last year of education, associate's degree. Does read and write in the English language. Is a U.S. citizen and no military service, Your Honor.
All right, thank you. And I believe I saw in the file service of the arrest warrant yesterday, June 17, 2021. Ms. Schiffel.
Thank you, Your Honor. Yes, I have a try-by date of Wednesday, September 15th. I would suggest Tuesday, September 14th. The state would anticipate at least a week-long trial, calling nearly 20 to 25 witnesses.
I see. All right. Possible trial date, September 7.
That should be fine with the state, Your Honor.
That works, Judge.
Okay, we can aim to start a jury trial on Tuesday, September 7. For a pre-trial hearing, I could see you on August 16.
Could we do the afternoon, please?
Could do that.
Agreed, afternoon.
Okay, so there, I can see you, it looks like 2, 2:30, 3, preference.
No preference from the state.
3, Judge.
At 3? Okay, we can aim to meet then at 3 p.m. Monday, August 16, for a pre-trial hearing. Thoughts from the state on bail?
Thank you, Your Honor. Obviously, given the nature of the charges, Your Honor, we are requesting a substantial cash surety bond, no 10%, in the amount of $3.5 million. I believe this bond request is justified by examining Criminal Rule 46C factors for the court. The nature and the circumstances of the crime charged. Obviously, with 2 murder counts, Your Honor, you can speculate as to the seriousness of what occurred. But to give the court a little bit more factual background, the victim in this case, Emily Noble, was last seen alive on May 24th, 2020, celebrating her birthday with her husband, the defendant, in Uptown Westerville. When she returned home that night, Your Honor, she was never seen from or heard from again. We now know after her body was found on September 16th of 2020 that Emily was brutally assaulted and suffered multiple facial fractures shortly before her death. We also believe the evidence shows that she was manually strangled, that strangulation caused 4 fractures to 2 different bones in her neck. Your Honor, the strength of the evidence against the defendant and the identity of him as the perpetrator is strong. We have cell phone forensics that we believe will show that the last time Emily Noble was heard from was shortly before she returned home on May 24th, and that the last individual she saw and had contact with was her husband, the defendant. The defendant has given conflicting statements that do not align with the cell phone forensics as to what occurred when they returned to the home. Your Honor, the defendant does have ties to Delaware County, but he's only lived here for a few years. During that time, to the state's knowledge, when he was married to Emily, he was not employed. Your Honor, the cell phone forensics also demonstrated a little bit about the character and the mental condition of the defendant to be considered by the court. It's clear he drinks to excess, and that this was a point of contention between him and Emily. There were multiple times where there are references to blacking out. Also, Your Honor, a search warrant was conducted on the residence shortly after Emily's disappearance, at which time evidence was found demonstrating that there was an attempt to grow illegal mushrooms in what was his deceased son's closet bedroom. There was other evidence of suspected drug abuse located in the safe. Your Honor, the defendant has also been prescribed a number of drugs in 2020 during this offense. I obviously can't speak to whether or not he is still taking those prescribed drugs, but some of them included diazepam, temazepam, and zolpidem, which appear to be related to the text messages about anxiety and a sleep disorder. Finally, Your Honor, to the state's knowledge, the defendant, he's not on probation or community control. There have been 2 instances, one which was several years ago in the state of Las Vegas, Your Honor, where the defendant is originally from, prior to moving out here to marry Emily. In that incident of domestic violence, the CCH report indicates a finding of denied. But in that case, Your Honor, he was accused and arrested for strangling someone else. So obviously this concerns the state as a potential pattern. It also, Your Honor, shows that he could be a danger to society if let out. There's also another incident where the disposition shows that he was not convicted, but it's important for the court to know he carried a firearm into a court building during a child custody matter. Your Honor, if you consider the other types of bonds set in recent murder cases in Delaware County, $3.5 million is in line with those previous orders, ranging from $5 million to $2.5 million. Your Honor, if you should post bond, the state would request a GPS electronic home monitoring, no contact with Emily's family, and a surrender of all firearms. We do know, Your Honor, he has a CCW permit. There were firearms located in the home, and we would ask the court to order that he have no access to them.
Thoughts on that, Mr. Gavin?
Yes, Your Honor, I think the state's request is excessive. I think there's no evidence of flight in this case, and the best evidence is that Ms. Schiffel indicated Ms. Noble went missing in May, and there's an extensive investigation. The body was found in September, and there was no Mr. Moore, who has been in the state for the last 5 years, didn't flee. If he was guilty of something, if he had a guilty conscience, he would have left a long time ago. Ms. Schiffel brings up 2 potential incidents and correctly notes No convictions for either of them. As far as I'm concerned, there's no convictions for Mr. Moore for anything. Ms. Schiffel brings up cell phone forensics and other things, and I agree. Those are things that the state did. They took their time and they went months and months, and even Detective Grubbs testified in a probate matter in November. They don't have evidence to arrest anybody. So now maybe they say what the findings of the coroner's office has changed things, but these cell phone forensics, these things she's pointing to, they've had for months, and they haven't arrested Mr. Moore or charged him with anything. So I think the situation is different. If you look at flight, potential risk for flight, there's no risk for flight. His father is here today, he can stay with his father. We wouldn't object to electronic monitoring or GPS monitoring. All these other things are allegations. We vehemently deny the charges. I just think that if they had any evidence, they would have charged him sooner. And the charges now is really the only difference between today and back in September when the body was found, is they're alleging that it was not a suicide. And that's something that a jury will have to decide. But speculation and charges that lead to not guilty findings shouldn't be used to set bail. We think bail in the amount of $100,000 to $250,000 is much more reasonable, and ask the court to do that. And after the court passes on bond, we have two other really brief matters to address with the court. Thank you.
Yeah. Bail is set at $2.5 million. Be posted by the deposit of that amount in cash with the clerk, filing of a surety bond at that amount, by the granting of a lien on real estate here in Delaware County, valued at least $2.5 million. While the case is open, Mr. Moore is not to have any contact with family members of Emily Noble. If he does post the bail, he'll be placed under house arrest with a GPS monitor to track his movements. He'll be under the supervision of the staff here in the Adult Court Services Office. He must report there whenever he's directed to do so. While the case is open, Mr. Moore is not to use or possess any firearms. And the same goes for any alcohol, any illegal drugs. He must report for drug or alcohol testing whenever he's directed to do so by the pretrial staff here. Other matters, Mr. Gabriel?
Yes, briefly, Your Honor. I think the parties are in agreement, and I'll submit an entry next week, but I don't really make a motion that the remains of Emily Noble will be preserved for potential further testing through the defense expert, and I think the state is in agreement with that request.
No objection.
Oh, you need an order from me.
Well,
Do you need one?
I'm not sure if we do or not. I know that the state is true to their word and has notified the folks, but I would feel more comfortable if we had a court order, so I will submit one with approval of the state.
Oh, very well.
The other matter, can we approach?
Sure. Do you need a record?
I'm sorry?
Do you need a record?
No,
Oh, okay.
at least not at the moment.
your son's going to jail.
I'll send you two.
Your son's going to jail. We know you did it.